today, a good way to take this was to look at the two aspects, the technical aspect of power of attorney, limbs, titles, property bags, etc., but also the marketing or the sales aspect. What's in it for us that we can use with a vendor? When I thought about it, and listening to a few things just very recently, the whole idea of knowledge is power is something that we've really got to embrace. You've just gone through quite a process and still continue to go through with the AML. And of course, that whole process is tied into titles and ownership structures and all those sort of things. And it's not going to get any easier as you go down the track. So one of the things I thought about, well, what can I use my knowledge on titles and limbs and all that, how can I use that when I go to see a vendor? Because you get the phone call to go, this is the property, and you're right in that mindset. You're competing against another agent who's got nowhere near the skill level of you. Go in and they tell all sorts of things, and listening to a micro ad coming down here, watch out for the agent that tells you he's got all the buyers and he'll get you the best price. So what can we add to our vendors at that particular time? So one of the things that I'm going to cover off is just a little bit of talk about how we come to titles, how that can be very, very valuable to us. But one of the key things on, how do I operate this? Just that one? Okay. The power of attorney, the enduring power of attorney, and the different forms. And the reason we added this in the beginning was because just recently, Brian, I think, had a situation arise at an auction where that became an issue. So there are two key types of power of attorney, two main ones that we use, and obviously you're all aware of a standard power of attorney form, and I've got a copy of one that's actually my wife and I power of attorney. I'll give you an idea. You've got the power of attorney for health and the power of attorney for property. Now when it says property, don't get confused by that meaning the house. Property means all tangible assets, money in the bank, shares, all those sorts of things, that power of attorney. It just so happens that we think of property as being a house, but in fact it actually relates to property of all types, and also to the health and the mental capacity of the person who's nominated on the forms. The main difference between the power of attorney and an enduring power of attorney is that a power of attorney document, and we're going to have a look at one or two of those, simply assigns your right to sign to another party. An enduring power of attorney has effect after that person loses their mental capacity. And for most of us, that is where we're seeing the power of attorney. Mum or dad or grandma or whatever it is has gone into an aged care facility, has become a little bit gaga, and so the son, the daughter, grandchild has taken over in the full power of attorney there, that enduring power of attorney. That comes to an immediate end upon that person's death. Alright, some people think that I can sell a power of attorney, grandma died on power of attorney. It doesn't. At the point of death, that is the end of any power of attorney, and then the executor of a will take over. In the absence of a will, I think the public trust get appointed by statutory thing, and they will then handle the property. So you will see titles which said that Michael Guy as executor of the will of so and so person. So the first power of attorney form, it didn't come up on the sheet, there it is there. This is just a sample of what you might see when someone says their power of attorney. So if they say a power of attorney, you actually want to see a power of attorney form from them, okay? For them to say they've got it is not good enough, and I think that was probably what caught us out a few weeks ago here. And you'll see, this is a fairly standard lawyer's enduring power of attorney. Now, it has to be completed by a lawyer, signed by a lawyer, and that will have a number of things noted on that form. And if you just go down to the couple of lines down below my name and Roland's name there, it actually gives the instruction as to how to act. In general authority to act on my behalf in relation to the whole of my property, being everything that this person owns. And it came into effect on June 1999. So from that point in time, at any stage, I can sign a document on behalf of this particular person who was non-related to us. And so for those 21 years, that has been the case. In some instances, you will see there that they may knock out the general authority, and they may put the authority to act on behalf in respect only to, and then they will go through and nominate what those items are. So it might be just in respect of the sale of my house should I become unable to act on my own behalf. So it can have restrictions. You need to watch out for that. Okay, this one here is just a carte blanche. I can act on behalf of this person at any stage, as can my wife. You will notice it has been signed and authorised by the solicitor, and also signed by the person in giving the power of authority.
Can I just ask one question?
You can.
I didn't realise that power of attorney can have two people being jointly power of attorney.
Yes.
So what happens if you and Bronwyn disagree on?
No, it's individual. It's either or. Bronwyn can sign on behalf, and I can sign on behalf. It's not an
But what if you have to do something and Bronwyn says she shouldn't be doing that? She wants to be running.
Well, she would just act as though she is the person given the power of authority as well. We would have an argument, and that is one of the things that you need to. And to tell you what happens in our case, she wins, all right? It was actually her friend, and this friend has absolutely no family. She's 89 in the world, except some ancient sister. She's 89, going to 90. Her sister in Canada. So. Hence, many years ago, she needed to cover her aspect. We thought she was old back then, she was 69. Doesn't seem so old now. But this was done for her. So at any stage, we could act on her behalf. We also have a similar document, which I haven't brought here, but it simply says in regard to mental capacity or health at the top. And with a form like that, so if they've got, just sort of cover this off for you, if they've got a situation where your power of attorney says that you can only act when I become mentally incapacitated, right? And they walk in here and say, Mum's mentally incapacitated, I'm acting. Unfortunately, they need to have a Form 4 and a Form 5 filled out. Now, a Form 4 is in relation to the mental incapacity, and a Form 5 is in relation to that person's mental incapacity for you to act on their property matters. Okay? So some people don't want a power of attorney if they've got their own mind and capabilities. However, should I have a car accident or anything like that, or become old and sick, I need to have a system whereby someone takes over. That has to be authorised, and you can see on the bottom of this form here, Dr. Andrew Barker, North Shore Hospital, he actually filled that form out at the time in the hospital for me to act for that person for both their mental health and well-being and also their financial matters. And this generally happens in the health at the time they're going to probably pass away. So they're going to want someone to make a decision to pull off life support or something like that there. It also applies to property. So you may have an elderly vendor who's become ill, and the power of attorney was to the son or daughter. If they become mentally incapacitated, well, they need to have that, they call it invoking the power of attorney, and it needs to be signed, and we need to see that it has actually been legally invoked. Any questions on that? Hopefully most people just have my power of attorney and they can act. But you need to have the document, have a look at it, rather than just take it on their word. And the auctioneer, both in Bailey's and Auckland, will ask you for that as well. Now this power of attorney form you saw there is real simple. It's 1.5 pages. Costs a couple $100 for your lawyer to draft up. The really great news is with the AML and what have you, it's all changing in terms of what the form looks like. And I put it on here just to give you a bit of an example. You don't have to look at it or read or anything like that there. But this is a enduring power of attorney. They are now about that thick, right? So the lawyers get more money, and it just goes on page after page. So you will see these new ones come through over the next 10 years or whenever. Someone may well sit with this form here. It needs a little bit more reading. The main significant at the time of preparation is two things. First of all, cost. The lawyer will charge you more. And the second thing, the lawyer can no longer act for you on witnessing and signing the document as part of the AML thing. He then prepares it for you. He will sign his bit. He's got to trundle off to a friendly lawyer and say, well, you sign this document, witness all this stuff. So he can't witness my signature and Robin's signature on our during the power of attorney anymore, even though he's prepared the document. So I just brought that up for you to have a look. This is one of the forms that's been a little bit contentious, and we haven't handled this really well over the years. And this is certification of non-revocation of a power of attorney. And I've got to say the banks haven't handled it well. I was talking to Finn about this the other day. I walked into the ANZ bank with that 20-year-old power of attorney and just took over all the bank accounts and everything of this person. They didn't ask was it being revoked or anything. However, if you've done work for a financial institution selling a property mortgage sale, or if you've prepared a mortgage yourself and you see the bank being signed, you'll actually see a power of attorney by that bank employee also attached to your documentation. I noted it on a property the other day. So when you're going to go and get a listing done, and they say their power of attorney, if the power of attorney isn't fresh, isn't a recent document, then please ask for a certificate of non-revocation from the person that's alive. Okay? So that's basically saying the document you've got, it matches up and hasn't been revoked. Because you may well walk into Bailey's auction rooms here or in Auckland, and the auctioneer asks you to see that revocation, non-revocation form. If you're doing a 4-week campaign, I'm of the belief that at the time of listening, if you have it, it's fresh enough to last through the campaign. If you haven't got it at that stage, you definitely need it at the reserve set form at that time of selling the property. So just be aware of it, it's on the cloud, and it's a very simple form to fill out. Now, why is this all becoming important? Well, you all know with the AML, I'm sure Kirsty's pulling her hair out and Ruth even more and more as these things become more and more evident. Please make sure you get them, because it does all tie in to the whole process. Now, can anyone else tell me about any other forms we use for power of attorney in real estate? So we go to the next sheet. Right. So we have a simple form called a trustee authority. So if you think about this, you have 3, 4, 2, 1, whatever, or 2, 3 trustees.
This one's not in the pack. Yeah, this one's not in the pack.
Oh, okay, this one's on the pack. That's why they didn't know, because I'm going to ask a question. There we are. Okay, so everybody familiar with the trustee authority when you come to do it? Okay, and we changed this because when you have a trust owning a property, and for some of you that are on trustees and you do your annual accounts, the solicitor may ask you to sign the minutes for the trust, and there may be a number of things on there. If you're selling the property, the trust will put in a minute that they've decided to sell the property and everybody's agreed to it and it's initial. And he doesn't do that at the time you do it. They generally do it at the end of the financial year when you're doing all the bits and pieces. This trustee authority says that one of the trustees can't be there, and the most likely person to sign this is the solicitor or accountant trustee, because they don't want to come to the auctions and be part of it. But it may well be that you are a trustee, and so it does say here that by way of resolution passed unanimously by the trustees. So they've had a trustee meeting, allegedly, right? Being authorised to act on the trustees' behalf, sign the listing authority, set and vary the reserve price, set and vary the standard terms and conditions at the auction, or change the asking price that it's been listed, determine and negotiate the powers of sale post-auction, and sign a contract on behalf of the property. So that covers the whole gambit of what we're talking about in our sale process. And then they sign it all off. And that document must be in your possession and signed by all the trustees. And also you need to point out to them that little clause about you've had a trustee meeting, and it needs to go into their trustee book, because that's what it's saying. They had a meeting and you're going to go into there. There's a couple of interesting things to just be careful with trustees. Okay? The law actually says a trustee can allow the other trustee to sign the document, can't actually allow the other trustee to make decisions. This tries to get around it by saying, for the sale process, we'll let the other trustees drop the reserve price. Okay? Probably a bit of a grey area, but Bailey's think it's good enough. Let's go with it. It's good enough. But if you're a trustee, the only time you can assign Another trustee to make a decision is if you've left the country. Okay? If you left the country, then that's okay, there's a document you sign to do that. So just be aware of that. The solicitors, generally, they just sign it for you and they'll let the vendors, who are generally mum and dad, do it. But you know, everything's changing because what is causing lawyers to be, and accountants to be really scared now, as you've found out, as you've gone to ask them for all their statement of finances and all those sort of things, is that with a change in the law is saying now there is very little protection for trustees behind the Trustee Act any longer. So the personal assets of trustee may well come into being attacked if one of the other trustees does something wrong in their personal life or their business life, and all of a sudden your name pops up in the title. So you will see a number of trustee titles actually start to change, where they become, and I'll cover it off very soon, limited liability trustee companies. So it's getting more and more complicated, and that is putting protection around the trustees. How I know about this is that I'm just spending thousands of dollars ring fencing or changing all our trustees, Ronnie and myself, and a trustee company as the owners of our properties, and we're changing all that to be a trustee limited liability company, because we want to ring fence and protect ourselves. And I guess other people will start to do that. The other form that you see, it used to be that bailies would only accept an enduring power of attorney on property as the authority to do it. And so I raised this with a solicitor, and I got into a discussion with a solicitor on this. And he said, you know, you can actually have just a handwritten letter from Gary, you can't be at the auction, you've given your wife the power of attorney. And I said, I've been to Auckland, they said, no you can't, no you can't. And he said, yes you can. He said, Gary, as the auctioneer, how many times do you sign a sale and purchase agreement on behalf of a vendor? And I said, I can tell you, it's probably thousands of times. So, he sent me this. So what gives you that right, Gary, is the auctioneer under clause 4, if the property sold at auction, I would authorise you to sign the contract on my behalf. It's not an enduring power of attorney. He said, that's actually a power of attorney, right, for you, so the auctioneer. Now you would have noticed the habit change, particularly in Auckland, and I changed as a result of what Auckland are doing. As auctioneers now, we don't sign the documentation. Now, and generally, unless it's on behalf of a bank or a mortgage company or something like that. And the reason behind that is that when I was signing that document there, I was assuming at all times every document you had all the way back to the time of listing was all signed correctly, and I could prove that, right? Because if the listing authority wasn't signed correctly, you didn't have the authority to sign it, and I'm signing the property at the time of auction. That was the problem that we had, okay? And of course, with the changes the way, there were a number of cases actually that happened where, you know, the poor accountant got verbal instruction from his client to sell the property, he sold it, and unfortunately, the client then changed their mind, and the accountant got absolutely done, and unfortunately they have insurance, because in reality, the proper power of attorney hasn't followed through. So, do you understand what I'm saying there? I don't know, for those who've done auctions, have any of the auctioneers signed on behalf of your vendor recently?
Not recently.
Not
Last
recently.
week.
No. That they may do.
Last week.
Last week, okay, you may do. You may find that just absolutely needed to be done. And I must admit, I had done it, well, before I finished, there was a case I had to sign. Now you can sign it, that's okay. But I do know, I don't know whether Ryan still does it, but probably you guys don't realise, I'd go and look at the listing authority and I would go through every document for probably the last 3 to 4 years. I'd go on the cloud, the list gave me access to look at everything, and that's why it was really important that we could see all those listing authorities and just checking everything was signed. Yes?
The other point is that sometimes your vendors don't understand what they think they've got authority for too. So when they say that they can do this, that and everything else, that needs to be very defined at the time of listing.
Absolutely.
Because I think the longer you leave it when it's not actually correct, it just becomes a bit of a drama that you don't need.
Yeah.
And may even cancel the auction if we haven't got that authority.
And that's the scary thing, and I think that's, you know, what Ryan and I face, is that you come to auction day and you're half an hour out, and you find out there's a signature missing. you know, you spend five.
Gary, when an auction is booked, can you just clarify, my understanding is in the process of booking an auction, when you bring a listing in, when that auction is booked and lodged with the auction department, that is exactly what that $495 covers. They go through and they check the listing form and everything's signed correctly. They check if there's any additional paperwork requested. Is that not been happening?
No, that doesn't happen. No, that's not the auctioneer's role. That is the, well, I don't know how Auckland can do that because they don't access our file, but that's actually starts at the manager, managers. That actually goes back to the manager's role in the business.
Because that's been, I mean, obviously I do quite a lot of auctions in the
Yes,
city.
yeah.
That is part of exactly what that is. I've had requests from Daniel and he's gone, you haven't got this or you need this,
Yep.
have you got that? And I haven't sent it through. Or I think, who is it, Louise?
Yep, Louise will
Louise
check
does
it
that.
through and do it. And
So
we'll all become more and more.
Can we still trust that process or do we need to do something else?
Well, definitely, like, look, Auckland have got that process in place, and we've got that process in place reasonably well now. But it doesn't always work because Ryan's busily managing.
Because ultimately it's not you're just the auctioneers, us that are in the firing line, it's us as well. So
Yeah,
we should be working through that.
but it became the auctioneer's basis in the firing line because he signed the sale and purchase agreement. So the purchaser signs it, the auctioneer signs it, and then you get a disgruntled partner. And all of a sudden, what authority has the auctioneer to sign this? Well, this is the only authority. There's nothing in the Auctioneers Act that empowers an auctioneer, unless a purchaser or a vendor refuses to sign at the auction under sort of like a hostile environment. Okay, then the law allows the auctioneer to step in. In fact, I spoke to a solicitor a couple of years ago, and he said, I have an agreement in front of me of a house transaction, and the auctioneer signed on behalf of the vendor and of the purchaser. So it was signed by both parties. And it was a common practice from one of our competitors out there. And I said, man, he said, I know, he said, I see it all the time from this company, but it's been auctioned, and the law actually allows that in certain circumstances for Ryan to step in. So particularly we see it in mortgagee sales and that sort of thing, and the bank will direct us, or something like that. In that case, they'll say, hey, we just sign that, and we used to pay a deposit of $1, and just to make the transaction be in terms of having some sort of consideration. So the answer to that is yes, Louise and that, they are pretty vigilant on that, but it does actually come back to us at the time of listing, and also then to our managers, and then to Kirsty, who stands in front of the RSA and REA and says, I've got a proper training process in place and supervisions under control and all this sort of thing. Now, do other companies do all this stuff on listings and titles? I can tell you absolutely no. Right? I went to buy a property the other day and I said, I got this agreement through, and it was from the vendor, and I rang the agent up from a top brand. It wasn't Bailey's. I said, how does a dead person sign this? They said, what do you mean? I said, the lady's dead. She said, yeah. I said, well, who's going to sign the agreement? She said, public trust. And I said, can I give you a bit of advice? I said, I suggest you put the public trust's name in there, and you put a public trust will want the disclaimer document limited to the liability of assets of that debt. That was an agent been in real estate 15, 18 years, and was a top agent from a top brand. Okay. So we all get caught and tripped out with it. So any other further questions on power of attorneys and signing?
Thank you. So if we have like a vendor in another town or overseas,
Yes.
and we're taking something to auction,
Yes.
should we get that signed?
That on there?
Yeah.
Yes, we
So
should.
for instance, a vendor in Christchurch.
Yep.
Go ahead, all the listings formed, and Daniel signed the auction authority, the auction document. But I don't recall seeing one of those. Should one of those have been signed?
That's the auction reserve.
So no, with Daniel, allowing Daniel to,
I printed off the cloud a week ago.
not the reserve form, the enduring power of attorney.
No,
That they can act on your behalf.
that one there.
Yeah.
The vendor's got that prepared by their solicitor. We want a copy of it. We don't sign it. You need that at the time of listing.
Not an auction.
No,
Okay.
no. But Daniel will ask to see it at the time of auction.
Yeah.
So you need to get a copy of it.
Just while we're quickly on options, can you just confirm with regard to the pre-auction protocol that there's a Bailey's protocol if the agents don't get that signed appointed listing, you confirm that they can't actually manage that process without getting authority from the vendor to run with our protocol?
Yes, yeah. Our auction package has a methodology for selling private auction. You must explain that to the vendor at the type of listing and get them to sign off on it. So if anybody comes to you and says, oh, I don't want to do it this way, sorry, at the time of listing the property, I fully explained the process. Should you, a person like you come along and try and bully me, and we have all agreed that I will not be bullied, and on your behalf, on his behalf, or her behalf, you follow this process and go through it. If they then throw out all the toys and they're a super great buyer, you go and see Debbie or Kirsty or Ryan.
Because it's also part of the reason they cancelled the ability to get the deposit released early, because what would happen is that you'd sell the property and everyone's so excited, and the agent shoves that form in front of a purchaser saying, you know, it's fine, just get rid of the deposit as quickly as possible. And now that is not possible because often the buyer didn't understand what
Yep.
they were even giving authority to.
Yep. So you must explain to them the reason behind that and why you're doing it. And if you want to confound anybody, and I'm not sure what our defence is, but if you're doing a deadline sale, just simply ask the agent for their written protocol and how they're going to handle the process. All right? Because it's quite clear from the REA they want a written protocol on multiple offers. They want a protocol to be available on tenders, and that's actually on the Bailey's tender document on pages 2 and 3, I think, and for options, okay? And so the deadline sale is something that also you need to ask what the protocols are. Okay, just moving along because time is marching on. Titles. I want to just briefly go through the titles and look at what we need to be aware of, what our pitfalls are, understanding the type of ownership, and I'm only going to focus on a couple of the different ownerships and the interests that are involved in the title. Can I ask you, when you get an inquiry to go and appraise or list or first look at a property, what do you take with you? What do you do before you go? Sorry? Before you go, order a title. Everybody do that? Everybody order a title? Great. When you order a title, what else from that title? Do you get all the interests? Do you pull out all the covenants? See some nodding head. If you're unsure in the game, can I make a recommendation that once you get the phone call, you get stuck in and pull the interests out and the covenants. Some of them are really clean titles, and I would say 85–90% of your titles are just mum and dad selling, and they've got probably a mortgage on there, and there might be a fencing easement on the title, and you'll have absolutely no problem whatsoever. But you're going to go out and compete against the likes of other companies out there, so why not arm yourself with a bit of knowledge? And one of the interesting things to look out for is look out for the mortgage. Now, why would you look out for the mortgage?
Because you may think they'll get to the feeling where the vendor was restricted by the value of the mortgage they've got. They might be mortgaged right to the hilt, therefore they have no room to move.
Right. Really great answer for people taking properties to auction. They've owned it 2 years, they've got a mortgage on the place. Have they got the ability to sell it?
Either that or they're just refinance or something and sale on it.
Just refinance. Okay, so they've had a Westpac mortgage for 10 years and all of a sudden there's another mortgage on there in the last 6 months. Maybe completely innocent, maybe starting to tell you something. You look on there and you see a finance company that is outside of what, let's call them the Big Four, if you know what I mean. It's some sort of third tier lender that's on there. And you start to think, why is that? Now, either they will have friends in there and they're getting the money really cheap, but more than likely those lenders are lending because the risk element is a lot higher with the client that they're driving. The client hasn't been able to afford. So you're actually building up a bit of a picture when you go and meet these vendors, okay, of what these people are actually all about, why they're selling. And the title that I've just used here today is a very simple freehold title, which names 2 individual people there, and also a trustee company limited. I think one of the biggest things that Kirsty and Ryan and Deb have seen, and certainly I've seen, is sometimes when you pull a title out, it will have 3 names on it, and that's all it's got. It might have one name as a party, so the property's only owned by one person and another name. One of the key things to look out for when you pull a title out, or you're on Property Guru, or any of those other sites that we do use, is if you've got Gary and Bronnie Caldwell and Kirsty Mackey, right? That rings a bell, starts to ring a bell. Probably what it means is the Caldwell Family Trust, and the trustees being these 3 people, but it doesn't say that on there, right? And we run around, we try and get these 3 people signed, and so when the sale and purchase agreement comes through, or the auction documents come through, just have the 3 people's names on there, okay? It doesn't have the Gary Caldwell Family Trust, right? Or it doesn't have the 3 people as trustees of the Gary Caldwell Family Trust. So, really look out for that and really dig down. The first thing is to ask the vendor, is this in a family trust? Because I've actually had it here, and you've all had it here on auction day. Oh yeah, our property's a trust. Oh, okay. Who's the other trustee? Oh, my sister, and she lives in Holland, you know. And okay. How do we sort this out, Kirsty and half an hour, you know? And we've made some seat of the pants calls. Right. Sometimes we've had to have, oh, my sister's, she's available. We actually had it. She will send us a text message. So we actually had someone on a cruise ship in Alaska send us a text authorising that, and we've looked at each other. We can print this out and say, well, okay, that's you know, because how do you stop an auction 30 minutes out? You've got 5 live buyers. You know we're going to get way above the reserve price. You know, Ryan's chomping at the bit. He wants to get up there, and this will be flying. Okay, and we haven't got the signature because they forgot to tell you that their sister was going on a cruise to Alaska. How did it happen? How did it happen in this room here? You know,
Sorry, can I ask a question? Because we got thrown a bit of a curveball on an appraisal yesterday.
Yes.
The lady called us in, and when I pulled up the CMA on the title, it has that, so they're separating.
Yes.
It has that the husband and his mother and his father are on the title, and she was not. They've been married over 20 years.
Right.
And what she had done is she's gone to the lawyer and registered a caveat
Yes.
on that title. So
Yes.
I was surprised that that was flowing through to Property Smarts. How accurate is that? Because that was registered in kind of March this year.
Okay.
Do you know if it's quite, does it flow through to Property Smarts quite?
It comes from Lynn's,
Yeah.
so as soon as the lawyer puts it on Lynn's, it should flow through pretty.
Right, so we can kind of, I was surprised, you know, because
Yep.
she didn't mention that she.
Yep. So if you're doing a mortgagee sale, the bank will, some purchaser solicitor will do a quick title search about 5 minutes before the auction, because sometimes 5 minutes before the auction caveats get thrown on titles to block it. Finn, ex-banker.
Gary, but with the caveat on the property, it doesn't give the person the right to sell the property. They only have
That's
the
correct,
right
she's not an
to
owner on the yard,
Correct.
that's
So
correct.
they
Yeah.
only
Yeah.
have
I was
the
gonna
right
come to
to get their asset out on the sale of that property.
Correct.
So,
And so we're in a bit of an awkward situation because she's asking us for effectively a type of valuation
Yes.
in our appraisal.
Yes.
And she doesn't actually own it.
No, she doesn't. So a really good example. So what do we do, folks, with that scenario? So we've got a property owned by, let's say, the husband on the title is mum and dad, and you've got the ex-partner or ex-wife demanding information. Copy of the appraisal.
Oh, she's not entitled. You have to deal with the guy, don't you? People on the phone.
Right. So at the time of listing, really important to have that copy of that title and say to the husband or wife who is in possession of the property and on the title, right, you need to be aware, I'm dealing with you only. You need to sort out the other part. You want to pass on the appraisal, your information, so that when you get asked, you can say, please refer this back to my vendor client, and I really understand your personal circumstances, but I actually legally can't help you. Right? My authority comes from people on the actual title.
So does that mean we can't actually present the appraisal? You see, because the husband was there for
Yep.
5 minutes.
Yep.
The story she told us is that he's got the keys, he's in possession of the house, and
Yep.
he allowed her in, but she doesn't actually have access after
Yeah,
that.
so there is a backstory behind that.
Yeah.
It's quite a complicated matter,
Yeah.
but there is a backstory behind that that involves the husband as well.
The
So
husband
you
may
got-
raise, if the husband says to you, I'm happy for you
Right, so
to
then
engage my
yes,
ex-wife,
yeah.
that's fine, yeah. But sometimes these are hostile situations, and so we've got to take what is the legal position, and what is the position that the party's authorised to do. And if he says, please send everything to my ex-wife, all the marketing reports, all that sort of thing, that's fine. Because the issue comes in the sale and purchase agreement and the option documents, there is that clause that clear title's got to be able to, and if she digs her toes in and we can't get clear title, it's got to go through the courts, and that can be, we're ready to throw it out, so it's all too hard. So just be aware of that. The caveat is no ownership.
And I would address the appraisal to both of them,
Yes.
and then I would put a sentence on the appraisal saying, you know, we understand the title is in this, but we've been asked to appraise on behalf of this person and this person.
Yep.
Right? So you'd actually make it clear on the appraisal
Yeah.
that you're doing it for both of them and address it to
So the husband doesn't come back to you 6
So the
months
husband
later
can't come
and
back to
say,
you
well,
and
why
say,
did you,
well,
yeah.
hold on, you know?
Yeah, yeah, because believe me, people have really short memories.
And sometimes you may be better to get an independent valuation done
Yes, of
anyway,
course, yeah.
Yeah.
you know, so that you can step aside.
Yeah.
Gary, I know for a fact, as an answer to the first question, that recently there was no more than 2 weeks between a title that I had something to do with whether it changed ownership, the title names changed and it was popping up on the bureau.
Right,
It was less than 2 weeks.
2 weeks.
I knew because I knew when the solicitor had signed the documents and,
Yep.
and I checked and it was there.
But any confusion, any suspicion you have, rip out another title, right? That's why I hate seeing sale and purchase agreement come from other agents and it's got a 6-month-old or 8-month-old title on it. It's really not worth the paper it's printed on, because anything could have changed in that scenario. So, you know, solicitors, before they settle, actually rip out the titles right at the last minute, transfer and bang you a copy of what the transaction has occurred there as well. So also this particular title here tells us a couple of things. We've got a couple of interests there, and this is something I want to discuss, and I'll come to it just in a few slides on a trustee company limited and how we're going to handle that and what we're going to look for on there. On this particular title, well, actually we'll go to it now. Okay, so we've got a trustee company, CDS. Does everybody know and understand how to extract ownership from limited liability companies? Someone tell me the web address? Okay, great. Or Google it, right? Google, I always just Google it, Google search, okay? And you'll get this page come up here, so Angela put in CD trustees, and there it is sitting there. You'll notice a number of them. So it's either an accountant or a legal firm, trustee company limited, and they have set all these up to ring fence them as independent directors of this trustee company, right? And down here is the second page. So if you clicked on here, the directors, it'll pull out all the directors here. Now, one of the reasons lawyers do this, as opposed to having John Smythe as your individual trustee, is they put it into their legal firm. It's a legal identity. But the other good thing about it is sometimes, and more than likely, there'll be 5 or 6 or 7 directors on there, all partners of a law firm, or 2 or 3. Any one of those can sign at any time, right? So quite often I've had a situation with my own trustee company, the guy I always deal with has gone overseas. His partner can sign any documentations. So it doesn't just limit it to that one person. And they will advise you whether their Articles of Association allow that to happen.
But for the purposes of AML, you're still going to get the identification from all 3?
No.
No?
Oh, from all 3, as in the 3 people on the title. With the trustee company, you only need the one that they're acting. Does that make sense? So for a professional trustee, you do not need all of the law firm to do that. You just, or the accountants or whoever it is, the professional trustees, you need the person you're dealing with, only there's one needed.
And that's only for professional trustees.
That's just
the
for
trustee
professional
company.
trustees, the trustee company limited.
Okay.
So Kirsty, would you need one of these people's?
Correct. You
So
need one of them.
the AML documents for one of them,
Yeah.
but in terms of signing any one of them. can sign.
In certain terms of signing, any of them can do it, but from AML compliance perspective, you need one.
So if it's a family trust then, not a professional trust,
You still need, so in this one, you need Ross Herrick, Megan Herrick, and one of the professional trustees, ideally really the one who's active. So basically who is acting, you know, who would they consider their trustee.
It doesn't mean that at the time of selling the property, if that particular person was sick or overseas or something like that, one of the other partners couldn't sign it if that's what the Articles of Association says. Also brings us to a title which has a company on it. Okay, so there are a couple of things you're looking for there. Obviously, be really aware of your GST component, because a lot of limited liability companies are registered with GST. Does that impact on your sale and purchase agreement from the listing? And secondly, who has to sign what? So can someone give me, if we have a company ownership and there are 3 directors on the company ownership going to sell the property, and they say to you, I'm the major shareholder, I'll sign for it, what's the answer to that?
You've got to go to the Constitution and decide and go through the Constitution and determine what the Constitution says.
Right.
You can't just take it on your word.
Okay. And some people get annoyed at that. You had that? They, you know, look, I've owned this company for 20 years. I do everything. You know, those two other shareholders silent, and you know. The other thing is too that most constitutions, if they're just using a standard constitution, which most firms, small companies do in this sort of scenario, one of the rules within that constitution, not all the time, but the majority of the time, is that in any major decision, all directors must sign. Selling of an asset like the home would be considered a major decision, right? And you need to get that authorised and signed. Again, 99.9% of the time it will not affect you. 0.1% of the time, Kirsty will look at it and shoot herself because it's just the time when some smart aleck has called us out and said,
In 9 times out of 10, Gary, the Constitution is available in the documents there.
Okay, so this drop down here has the shareholding, documentations. And if you're a nosy beggar, you actually want to go and look at some of these things. So you can read a lot of things about personals, particularly if it's got a liquidation or something like that there. And then this is a personal property search register, if there's any finance or anything linked on there. But you do need to have an account to pull those sort of things out. The solicitor certainly does. If you have any issues, why not at the time of listing or seeing the vendor, say one of the things I really do require of you is access to your solicitor, right? If I have anything that is causing me concern. Most people don't want you to go to the solicitor and spend money. In your area here, what's your average sale price? 8, 9?
Yeah,
A $900,000 transaction, right? If I said you go out and spend $900,000 anything under the property, you'd probably take a bit of advice, wouldn't you? So if I've got a $900,000 asset that's a wee bit complicated, I've got to be able to talk to your lawyer. Now, what a great selling point to your vendor. Because if Head might throw a rip in and say, yeah, well, where's this and everything, you know, did you know that there was this covenant on your title? And I can tell you, people don't know, right? Do you realise that you have this issue?